You may be seated. Hampton Manor versus FORTNER. Hampton Manor.
Your Honor, can I please the court, Dean Morandi of Carlton Fields, here on behalf of the appellants, the Hampton Manor entities, who I will refer to as Hampton Manor. I'd like to reserve 5 minutes of my time for rebuttal, if I may. This appeal involves a straightforward legal issue as to whether the plaintiff failed to state a cause of action under the Florida Whistleblower Act. Specifically, the question is whether the plaintiff should have and must have alleged that Hampton Manor, again, individually or collectively, was an employer with 10 or more employees as required under the Florida Whistleblower Act. It's undisputed that she did not do so here. We move...
They alleged that she was employed by them, correct?
That is correct.
In 2 paragraphs, I think it says that.
That's correct. I think that's the closest they came. They did not use the word employer. They did not state that Hampton Manor was an employer under the Act, and even if you count the actors in the Third Amendment complaint, you don't get up to 10. So under no reasonable construction...
The evidence at trial revealed that they employed more than 10, correct?
That is correct. But we are talking about the failure to state a cause of action. We do not get to evidentiary issues if there is no cause of action stated. And that's what occurred here. We're talking about the Florida Whistleblower Act. There was no common law, and there is no common law action for retaliatory discharge. The legislature made a substantive policy decision to have this cause of action relate only to employers with 10 or more employees. It does not. A small business with less than 10 employees would not be subject to this act. So the legislature carved out the elements. It created the elements for a cause of action. Among those elements is that you have an employer with 10 or more employees. Question? No?
No.
You first raised the issue, 3 days before trial? With the
It would be the Friday before trial.
Right.
We raised it in a motion for judgment on the pleadings. It is undisputed that is timely.
All right. As far as the motion to conform the pleadings to the evidence, case law does look at the prejudice factor.
It does not.
Has there been any prejudice in this case for the trial judge, if the trial judge had granted it rather than reserved on it?
If the trial judge, I'm sorry.
The trial judge had granted the motion for judgment on the pleadings.
Yes.
Rather than reserve on it.
Correct. They would have had an opportunity to replead. But instead of...
Right. And would you have been prejudiced in any way by an amendment of the pleadings at that time?
Well, that's a good question, and that would go to whether the trial would be continued or whether they could continue with the trial.
Yes or no? Would your client have been prejudiced in any way?
I don't know the answer to that, but fortunately, it doesn't matter. Prejudice is not an issue.
Don't we have to evaluate the judge's decision as to, would it have been abuse of discretion for the judge not to have granted a motion to conform the evidence to the pleadings?
A couple answers there. We're not dealing with an abuse of discretion here, and we're not dealing with the denial of a motion to amend the pleadings to conform.
Right, and the trial judge never ruled on it.
That's correct.
If that's the case, don't we have to consider that issue?
Yes, but only to the extent that it is a legal issue. Let me give the timeline. As Your Honor.
But if we are going to consider it, then don't we consider prejudice or lack thereof?
Well, let me back up, and I will answer your question.
Okay.
We filed the motion for judgment on the pleadings before trial.
3 days before.
3 days before, the Friday before trial. Again, not an issue that it was not untimely. It was timely. Nobody's contesting that. It was argued on the first day of trial. Instead of asking at that point to have the pleadings amended, say, Your Honor, they're right, let's amend the pleadings. We failed to allege an essential element of our cause of action. Let's amend our pleadings. We don't think they have any prejudice. You should allow us to have this amendment, and we should go forward with the trial. That didn't happen. They substantively challenged the basis for the motion for judgment on the pleadings and argued that it was incorrect. By doing so, they chose to proceed at their peril. It's not a question of prejudice at that point.
But then they sought to amend after. And the rule of procedure provides that they can do it any time.
They can if an issue was tried by implied or express consent.
Did you object?
That did not happen.
Did you object to the question how many employees does Hampton have?
We did not object to that question during trial.
Well, isn't the case law that if you don't object, then it's...
It is not the case law. It's similar to a motion in limine, and I would direct this court to the Archie-Freed decision, which is a Florida Supreme Court decision. In that case, makes clear, we filed the motion before trial, they had it before trial, we argued it before trial, they substantively opposed it on the merits instead of seeking to amend, they went through their entire trial, put on their case, closed their case, we re-raised the issue of the motion for judgment on the pleadings. It was only at that point that they said, you know what, we better move to amend the pleadings to conform with the evidence. Well, guess what? That's too late. There's two reasons why. There's two reasons why that argument fails. First of all, it's too late, and I would point the court to the Shopler decision, which we've talked about.
Which you have to show prejudice, because otherwise it's directly contrary to the rule of civil procedure.
Shopler did not involve a question of prejudice.
The rule of civil procedure specifically says that you can amend after all the evidence has come in.
Absolutely.
All right.
But only if it was tried with implied or express consent.
If the trial judge had not ruled on the issue, on the motion to, amend the pleadings, or had reserved ruling on it, then wouldn't you have been obligated to object to the question about the number of employees?
Not when it's been raised and they are on notice of this issue. Well, they know that we're substantively challenging this issue. There's not a whole lot more we can do. It's the same thing with a motion in limine. The same rationale applies. If you raise a motion in limine for evidence coming in, you do not have to re-raise that objection each time.
It's a dispositive ruling from the trial judge. That's what the rule says. And here there was no dispositive ruling because the trial judge reserved.
There was no dispositive ruling, but it was re-raised.
If you want to compare it to the motion in limine rule, you have to re-raise it during the trial unless the trial judge had made a dispositive ruling. Here the trial judge had not made a dispositive ruling, and the objection was not re-raised during the trial. So that evidence came in without objection.
The evidence did come in without objection, but we're talking about, you cannot conform the pleadings to state a cause of action where none was otherwise stated. You can correct pleading defects, but we are talking about the failure to state a cause of action. I'd like to point the court to a case that we talked about in our reply brief, which I think is pretty apt in this particular situation, talking about whether something's been tried with consent.
Let me go back to the central elements. Would you agree that the fourth DCA did not list a requirement as an element of the 10 employees? That's not the pleading.
Well, I would say that they said that it's got to be a protected employment decision. So obviously, to be a protected employment decision, you have to be dealing with an employer under the statute. I would like to get back to the other discussion we were having, but I will move into that when we're talking about it. Again, I think if you look at the statute, you look at the legislature created this cause of action, explicitly determined that it does not apply unless you have 10 or more employees. It's not an employer as we think of everybody being an employer. It's a specific definition of limited applicability under the express language of the statute. So that is an essential element. We could look at it like this. Let's look at their third amended complaint. Let's say that they have proven every factual allegation in that complaint. They still have not proved a cause of action under the Florida Whistleblower Act, because nowhere in that complaint are there any factual allegations that Hampton Manor, employed 10 or more employees and is subject to the Florida Whistleblower Act. It's the simplest way to think about it. When you talk about a failure to state a cause of action, that's exactly what we're talking about. So if we need any more authority than that, we've cited probably 10 federal decisions making it clear under similar remedial employment statutes that show the failure to allege the number of employees element results in a failure to state a cause of action, and the complaint must be dismissed.
The federal cases talk about jurisdiction.
Well,
Would you agree that's not applicable here?
I do agree that's not applicable here. But the point here, and I don't want to get off on a red herring on jurisdiction, let me discuss the 11th Circuit intra-circuit split that we were talking about. The issue there was akin to to personal jurisdiction, I would say. I would use an analogy to personal jurisdiction under Florida state law, wherein if you've alleged personal jurisdiction, allegations to support personal jurisdiction, the trial court has the ability to take evidence to determine whether personal jurisdiction exists. In those cases, the question was, if you have a well-pled allegation of the number of employees, does the trial court have the ability to become the fact finder and determine the truth of that allegation, or does it have to go to a jury? That was where the circuit split was. For our purposes, it makes no difference. The point is, in those federal cases, it makes clear that that number of employees element is an essential element of the cause of action. The only reason why jurisdiction comes into play is because it's also a requirement for jurisdiction for the cause of action to proceed. Now, a difference between personal jurisdiction and what we're talking about here is personal jurisdiction is strictly jurisdiction. It is not an essential element of the claim. That's why we use the 11th Circuit case law. Then that's why jurisdiction is a little bit of a red herring here. It's important in the sense that it shows that we're talking about an essential element that if you don't plead it, you fail to state a cause of action. So, we also have the numerous district court cases talking about the failure to allege this number of employees element is fatal to stating a cause of action.
Would a pleading be acceptable if it alleged that the defendant was an employer as defined by the statute?
I'm sorry,
If the pleading said the defendant was an employer as defined by the statute?
I think that would be close. I don't know that you necessarily have to say as defined by the statute, but with 10 or more employees.
So here they allege that they're bringing the action under the statute, and they allege the defendant's an employer.
I'm sorry.
In this case, they allege that they're bringing that particular count under the Florida whistleblower statute.
They did.
And they alleged that your client was the employer. They said they were employed by.
They did not employed by. They did not use the term employer.
All right. So if it's sufficient to say that someone's an employer as defined by the statute, are we really parsing things?
I don't think so.
We're bringing this action under the Act, and this person is in essence an employer. We're employed by this person.
You can split hairs on this issue as to whether saying defined under the Act is sufficient or whether you actually have to say have 10 or more employees. I don't know, and I haven't been tasked, and we are not tasked today with the issue of whether that would be sufficient. But what I can tell you is you can't just say, I'm bringing this action under the Florida Whistleblower Act. That's a legal conclusion. It's insufficient under legion of case law. And I think that's where we're going with that, and we can't do it. Fortunately, in this case, we don't have to worry about the slippery slope because we have no allegation addressing whether Hampton Manor is an employer under the statute. Whether you call it under the statute or whether you call it an employer with 10 or more employees, it's not in the complaint. They were alerted to this before trial. They chose to substantively challenge it on the merits during the trial. They put on their evidence. They closed their case. We re-argued the issue. They didn't ask to reopen their case. They asked to conform the pleadings.
So there's no reason to reopen it. They already had their evidence.
Correct. They had their evidence. That's why it's not.
They could ask to conform the pleadings to the evidence after they rested.
Right, but the rule allowing you to conform to the pleadings does not permit you to state an allegation that is an essential element of the complaint.
Is there case law to that effect?
Well, I would use the analogy to a default.
Is there case law to that effect? Can you answer that question?
There may be, but I don't have it off the top of my head.
Well, what would be the purpose of conforming the evidence to the pleadings if it wasn't?
To correct, let's say you had a factual allegation that was wrong.
Like a date?
It's like I say, Ms. Fortner was an employee of one Hampton Manor entity in the complaint. But it turns out through the evidence, she's an employee of a different Hampton Manor entity. You can move the pleadings to conform with the evidence. What you cannot do is, if you fail to state a cause of action, move the pleadings to conform to the evidence to state that essential element that was missing.
Aren't there cases where you can conform it to, in essence, prove a different cause of action than the one you allege? Everybody tries a case by fraud, although it was pled as something else. You can move to conform it.
And I go back to,
there was no cause of action for fraud alleged in the complaint, right?
if it was tried by express or implied consent.
Okay,
I agree with
so
that.
in that context, you can move to conform the evidence to support a cause of action which was not pled, right?
I think that is the case.
How is that different than your argument that you can't plead one, you can't conform to if it doesn't state a cause of action?
Because
in this scenario, it didn't state a cause of action for fraud, but you were still able to do it. What difference does it make?
Because we properly and timely raised this before the trial. They were on notice of the issue, and they chose to present their case in the manner that they chose to present it.
Well,
They didn't.
You presented it on the first day of trial.
Right.
At the same time, you filed a motion to conform the pleadings to the evidence to add an affirmative defense.
Right, that is correct.
And a whole bunch of other things. I mean, if you could have filed this motion a month ahead of time, right?
Absolutely.
And then we wouldn't be confused with what was going on at trial and whether there was evidence being presented.
I don't know that that's true. I have,
You could have presented it in a motion to dismiss, right?
it could have been presented in any number of ways. You're absolutely correct. But the point is, and it's undisputed, that it was timely. And it was argued before trial, and they did have an opportunity to request leave to amend their pleadings, and they didn't do it.
Since this was done right at the first day of trial, is this a case where there were pretrial statements filed, stipulations, those sort of things that are...
There were other matters being heard, absolutely. It was the beginning of the
You
trial.
have set forth what the issues were for trial, right? In your pretrial statements.
I'm not sure if there was a pretrial statement, but something along those lines.
And did you, in those pretrial statements, say one of the issues is whether they can prove we're an employee or whether they've alleged we're an employee? Or did you...
Well, that was in the motion.
With it on the morning of trial? That's is the first time that this issue came up on the morning of trial?
It was the first time it was argued. It was filed before. But again, I have to stress,
How much before?
it was time, I'm sorry?
How much before?
It was the business day before trial.
Okay, so until one day before trial, did you ever raise the issue that they had failed to allege something that they needed to allege? Or did you hold it back to surprise them with it on the eve of trial and hope that that would work and they would not have a chance to correct it?
I would absolutely suggest that it was not held back. It was filed on the eve of trial. Would it have been more prudent to do this earlier, as Your Honor suggested? Absolutely. I think the answer to that is no, but opposing counsel will correct me if I'm wrong. Whether it would have been waived by not raising it in a pretrial statement would have been an issue they would have raised in their answer brief.
Detailed stipulation of facts, though, correct?
That is correct.
Yeah.
Yes, there was an agreed stipulation of
I
facts.
mean, it really boiled down to whether the termination was related to the, I think that was the issue that y'all framed for the trial, was whether, that she was fired because of the whistleblowing. I mean, that was...
Right, there were factual issues at trial, but again, this is a legal issue, which was timely raised, not disputed that it was timely raised, and they chose to dispute it on the merits. I don't know if the court has had an opportunity. I filed a notice of supplemental authority yesterday. I hate to do it at that late moment, but I happened to find a 5th District case with similar
That
facts.
was written by Judge Eaton, though, correct?
That is correct. I just want to talk about what happened there.
Okay, you're down to about a minute if you want to save any of it for rebuttal.
I think I will save it for rebuttal. Thank you.
Good morning. Chris Roberts on behalf of Joyce Fortner, the appellee. This appeal seeks to take away a jury verdict after 4 years of litigation based upon the most hyper-technical gotcha issue imaginable, raised, as has been discussed already this
Well,
morning.
let me ask you, why, when they filed this motion for judgment on the pleadings, and you're arguing that it's not an essential element, that's fine. Why wouldn't you say, alternatively, Judge, can we go ahead and amend, I'm making Ori Tennis motion to amend and make this a non-issue, so we don't have to worry about this come appeal time. I mean, Seems to me that we could have worked out this whole appeal with an oriented motion to amend that the trial judge almost certainly would have granted, because there was no prejudice that I can see, and I haven't heard of any.
Yes, Your Honor, I went back and looked at the record on that issue, and I believe that what Judge Singbush did was to actually state before we even addressed the issue that he was going to give us the same opportunity that he was giving the defendants in connection with a motion they were making to amend one of their affirmative defenses, that he was going to wait and see what the evidence was. So he had already in effect ruled that he wasn't going to rule and that he was going to wait to see what the evidence was. So if we had asked him...
Why wouldn't you ask the court, I mean, when it came up, why take the chance?
Well, you're right, it was purely a matter of, the judge had already stated that he was going to hear the evidence, and then ultimately we did move. In hindsight, we certainly could have moved and perhaps should have moved at that point in time to amend, but we did ultimately do it, and the rule does allow us to do it in the time frame that we did after the evidence was heard.
There seems to be fairly liberal use of the concept of motion to amend to conform to the evidence, because the other side made such a motion not based on evidence that was coming in on trial, based on what was happening during discovery. And I've never heard of a motion to conform to the evidence based on discovery. That's usually what happens at trial, and you would just move to amend and then see what shows up. And so it was sort of odd that the motion was a motion to conform to the evidence by them, which really looked like it was just a straight motion to amend.
Yes, Your Honor. And ultimately, this issue, I should point out, was raised in a flurry of other activity, including that the lawyer that was representing Hampton Manor literally withdrew on the Friday before trial and a new lawyer substituted in. Despite that, nobody asked for a continuance on the basis of this motion for judgment on the pleadings. There was never argued that there was prejudice, and the issue was presented on the morning of trial almost as an afterthought by the new lawyer, who effectively said, well, I feel like I need to raise this since it's been raised as a motion, and I think everyone, including the judge, saw it as something that was sort of a hyper-technical argument that would be resolved by the evidence at trial, and that's certainly how we viewed it at the time. But getting back, I think, to the fundamental point, we disagree with the basic argument being advanced by Hampton, which is that this was required in the first place. There's no Florida case law that states that that the number of employees is a necessary element that has to be pled. Certainly the statute says that you have to prove there are 10 or more employees, but even the counsel for Hampton Manor concedes that there's no specific language that would be magic language. Looking at our complaint, our third amended complaint, we did allege in count 1, we named the Florida Whistleblower Act by name, we named it by statute, by chapter and section number, and we alleged specifically in paragraph 28, as alleged further in the earlier factual allegations, Hampton's actions caused Ms. Fortner's employment to be wrongfully terminated. This violated the Florida Private Employer Whistleblower Act. So we did use the magic word employer, we did cite the statute, and we did say the act was violated by the action. For Hampton Manor to suggest that in any way it went into this trial, not understanding that the plaintiffs intended to assert a claim under the Florida Whistleblower Act defies any possible logic. And as the court noted during appellant's argument, prejudice is one of the primary issues that the court looks to in determining whether getting to the motion to amend to conform, but even before that, whether or not it even needed to be pled in the first place. And we contend that the Florida pleading rules simply don't require it. And it's telling, reading from the defendant's own brief, that even Hampton concedes there's no Florida case that says you have to allege 10 or more employees in the complaint. So it's our contention this entire appeal is based upon a misunderstanding of the law and trying to hearken back to the old pleading rules that would require some sort of specific mechanical recitation of facts.
Let me ask you this. There was a stipulated statement of facts filed.
It was.
Were there pretrial statements as well, setting forth the witnesses, exhibits, issues?
Absolutely, yes. And we had a pretrial conference that the original attorney attended, the one who withdrew on the Friday before trial. He said he was ready for trial. Not only did he say nothing about this issue, he said nothing about needing to withdraw. He ultimately withdrew because he said he wasn't prepared.
Right, but was there a written pretrial statement filed?
I believe there was, Your Honor. Unfortunately, I don't remember specifically. I know there was a pretrial stipulation of facts that was filed. There was a pretrial statement which included all the check marks in terms of, who was going to object to what needed to be proved. So yes, there was definitely I don't recall its contents though, and there was also this statement of facts. And by the way, the statement of facts included, the stipulated statement of facts included that Ms. Fortner was terminated from these entities, that she was terminated after she refused to forge documents in violation of law, and that she was terminated very shortly after that. Really, the only factual issue that remained in dispute.
The issue was whether she was terminated because of that, correct?
Yes, Your Honor, and that really became the issue that the jury had to decide. The issue of the number of employees came up, and I think this is another important point. When the judge at the outset of trial said that he was going to hear the evidence, when this motion for judgment on the pleadings was first raised to him, that he was going to give us the same right that he was giving to the other side to see what the evidence was at trial, that is certainly, and I don't think there's any case law that says a motion for judgment on the pleadings is enough to simply sit back throughout the rest of trial and not object to evidence that comes in. But even if there were, in this context, where the judge specifically says, I'm going to reserve ruling and I'm going to hear what the evidence is, that would certainly trigger a duty on the part of the defendants to object contemporaneously at trial, to file a motion in limine, to object to a jury instruction, none of which was done in this case. There was literally no objection to the evidence. When the jury instruction was submitted at the end of the case, there was no objection to that, and there was no motion in limine filed. So literally the only way this was raised was by this motion, which was raised on the Friday, written in writing the Friday before trial, and orally on the morning of trial.
The jury instruction, did the jury instruction list the elements of the violation of the whistleblower statute?
Yes, it did, Your Honor, I believe.
Did it list that the employer must have more than 10 employees?
I honestly don't recall, Your Honor. And I know the jury instruction was not objected to. I know it referenced, I'm trying to think back, I know that it referenced the issue of an integrated employer employing a plaintiff. I simply don't recall if it specifically said 10 or not. But it's an excellent point to raise, which is whatever it said, it wasn't objected to. So when the jury ruled on this or decided on this issue and whether or not there was a violation, it had a jury instruction that received no objection from Hampton. I think another point that is worth raising is that this issue of amendment of the pleadings by consent, the rule also allows amendment of the pleadings even without consent, and Rule 1.1190. And specifically, the rule says that if the evidence is objected to at trial on the ground that it is not within the issues made by the pleadings, the court may allow the pleadings to be amended to conform with the evidence and shall do so freely when the merits of the cause are more effectually presented thereby and the objecting party fails to satisfy the court that the admission of such evidence will prejudice the objecting party in maintaining an action or defense upon the merits, according to the rule. So even if, as Hampton contends, filing the motion for judgment on the pleadings by itself with no objection during trial, no motion in limine, and no objection to the jury instruction would nonetheless constitute not consenting to the evidence coming in contemporaneously when it did, the rule says that the judge was still within his powers, and in fact that he should grant the motion to amend when there's no prejudice to the other side. And again, I don't think Your Honor's ever heard a specific answer to that question, but I can answer it for you, certainly from the plaintiff's, from Ms. Fortner's perspective. There was no prejudice to the defendants through any of this. There were, as the court has asked me, there were pretrial statements submitted, there was a pretrial statement of facts submitted, there were pretrial conferences. The motion was filed on the Friday before trial. It was clearly, in every sense of the word, a gotcha motion, saying, okay, we sat on this issue for 4 years, didn't raise it, and now we're going to raise it on the Friday before trial and argue it on the morning of trial. And there's no even attempt to argue that Hampton didn't know what the claim was or what we were going to try to prove at trial with regard to the claim. And again, the Whistleblower Act was specifically alleged in the complaint, so there couldn't be any reasonable argument that they did not know what it was we intended to prove at trial or what we intended to show or seek damages under. And in fact, this is a much easier resolution than the typical motion to amend to conform that comes before the court, which would be something where an entirely new and different type of claim is raised. And the only case law that Hampton was able to show the court that supported their position were cases where there was prejudice, where the defendant was able to come in and say, look, we had no idea this argument was going to be made at trial, we weren't prepared to address it, and it was prejudicial for the court to allow it to go to a jury when we objected to it and weren't prepared for it. And the case that Hampton filed yesterday, the Wynn versus Roth case, a very important detail in that case was that the defendant was unable to prove at trial the facts which he was trying to amend to conform his complaint to. So it had already been heard by the jury, it had already been rejected by the jury in that case. The complete opposite of our situation, where the jury heard the evidence without objection and made a decision that in fact the statute was violated, and the case ultimately resulted in a verdict for the plaintiff. Going back to the primary issue, the more fundamental issue as to what we were required to plead, I'd cite the court back to, and we cite the court in our briefing, to Ranger Construction, which talks about the pleading rules in Florida, that yes, it's a fact pleading state, but what that means is you have to plead sufficient facts that the other side knows what it is they're defending in court, and not that there have to be these intricate specific words that are used to trigger a particular cause of action. And I think the fact that Hampton's counsel was unable even to answer to the court what specifically was it the plaintiff was supposed to say factually that they didn't say, and the answer was, well, I'm not sure exactly what the words would be. They wouldn't necessarily have to say this, and they wouldn't necessarily have to say that. And again, we would come back and say, well, we did say enough, even if there were a requirement, which there is not. Even if there were, we did reference that they were an employer. We did reference the act itself, and that she was terminated. So it's almost a incorporation of the definitions by implication, that if you cite a statute and you allege that somebody fell under it and the actions of the defendant violated it, you're certainly letting the other side know that any applicable definitions within that statute apply to your case. And so again, getting back to the pleading rules in Florida, that's more than enough to satisfy the rules, even without regard to later moving to amend, which should have corrected any deficiency. The final point we'd make is, and it's sort of our catch-all argument in our briefing, which is the idea that Florida law strongly favors the resolution of judicial disputes on their merits as opposed to procedural technicalities. Again, looking at the history of this case, looking at all of the opportunities that Hampton Manor had to raise this issue, which they didn't take, looking at the manner in which the issue was raised to this court on the eve of trial, looking at the fact that the judge himself, when he heard it, simply said, look, I'm going to give the plaintiff, Ms. Fortner, an opportunity to present evidence on this issue. I'm going to reserve ruling. Given that the plaintiff did present evidence on the issue, given that the plaintiff did move to amend to conform to the evidence during the case as permitted under the rule, and that ultimately the jury found in the plaintiff's favor after 4 years of litigation, it's hard to imagine a more clear example of allowing a case to be decided on its merits as opposed to going back and finding a hyper-technical issue to take that verdict away. I should also mention, just as an aside, because I don't think it was raised in the briefing, that there were other counts in the complaint in addition to this, and there was in fact a count for conversion which went to the jury, and was another basis of the judgment. The jury awarded, it was a few $100s, but it was an additional judgment in favor of the plaintiff on that count. So any suggestion that somehow the case was solely, and getting back to this jurisdictional question, it's our contention that there is no jurisdictional question in this case. The federal cases that talk about this issue are talking about bringing a case in federal court under a federal statute which would convey jurisdiction on the court. And what those courts have done, in a few examples, is they've looked at the allegations and they looked at what the defendant says, and if there's a contention that the defendant doesn't have 15 or more employees, so that the statute would be triggered and the court would no longer have subject matter jurisdiction under the federal statute, the courts have said, well, let's look at it and resolve it, as opposed to going and having a whole trial on it before the issue is resolved. Totally different in the context of a Florida case, where we bring the case in a Florida court, $15,000 or more in controversy, multiple counts, including that one. And again, the statute is raised by name and by statute number, so there can be no prejudice and no surprise. So with that said, I think I'll conclude my argument. Thank you very much.
Thanks, Counsel.
A few things I'd like to briefly address. We've talked a great deal about Rule 1.190 and moving to amend the pleadings to conform to the evidence. One thing I need to make clear here, it never happened.
Well, let me go to the definitions as they're set forth in the statute.
Okay.
Because it doesn't say you have to be an employer who employs more than 10 people.
10 or more, yeah.
What it says is we're going to define the word employer as somebody who employs more than 10 people.
That is correct.
And we're going to define an employee as somebody who works for an employer. So if the allegation had said Ms. Fortner is an employee of Hampton, that would have met the definition of the statute, right? Because to be an employee, you must perform services for an employer.
I think that argument could potentially hold water if they said Ms. Fortner is an employee as defined under the statute.
Okay, that would have been enough.
I don't think so, but potentially. But that's not what they said.
Well, they did allege that she taught other Hampton employees.
Yes.
That means that Hampton, to be a Hampton employee under this definition.
Correct.
Hampton would have had to have been an employer under this definition.
I think
right?
I think the reasoning there is a little bit too circular. We're not talking about an employee in a general sense. We're talking about an employee as defined by the statute. Nowhere in that third amendment complaint does it say as defined by the statute.
If the complaint said that this individual was fired because she reported some unlawful act to the, Marion County Sheriff's Department, okay?
Yes.
And that she was fired for reporting an illegal act to the Marion County Sheriff's Department. Well, the statute defines appropriate governmental agency as any agency charged with the enforcement of laws, rules, or regulations governing an activity, policy, or practice of an employer.
Yes.
Would she need to say that the Marion County Sheriff's Department was an appropriate government agency which was charged with the enforcement of laws, rules, or regulations governing activity? Because that's one of the definitions right above the definition of the
because that's a reasonable factual inference by naming a specific agency whose general functions are as defined under the statute.
So
that's not what we're talking about here. We're talking about specifically.
So she has to say an employer, and then that's not enough. She has to say with 10, but she can list a sheriff's department without saying this is an appropriate government agency with charge of the enforcement of laws, rules, regulations, etc.
Right. If you were...
Is that what you're saying?
I'm saying, let me give you
Because there's 6 definitions here. So does she have to define in the pleading, a fact that comes within each definition, or can she just use the word appropriate government agency, employee, employer, law, rule, or regulation, retaliatory personal action, supervisor? Can she use those words, or does she have to, in her pleadings, put in each term of that?
No, I don't think so. No, I don't think so. For employer, I would have no argument if you looked in Webster's dictionary under the definition of employer and it was not materially different than the definition here. But the definition under the Florida Whistleblower Act is materially different. We're talking about an entity that employs 10 or more employees. It has to be explicitly argued. It has to be explicitly alleged. And we have legion cases of federal decisions saying exactly that. This court would have to write...
If the complaint said Hampton was an employer, period.
It did not.
No, if it did, would that be enough?
I would say, potentially, I would probably argue that it was not, but the bottom line is we don't even have to go that far here, because it didn't, and there's no question that it didn't.
If the complaint said she reported some matter to a sheriff's department rather than an appropriate governmental agency, would that be sufficient?
Potentially could. listen to the broadness of what you're talking about. Appropriate governmental entity means any agency of government charged with the enforcement of laws, rules, or regulations governing an activity, policy, or practice of an employer. Sheriff's Department, I think that's common knowledge. If you looked in the definition under Webster's for what a sheriff's department is, it would fall under that definition. We're not talking about a specialized definition of an appropriate governmental agency.
Thank you, counsel, your time's expired.
Thank you.
Court will be in recess.